I recently published an article in AMLAN discussing the procedural details associated with the attempt to get the United States Supreme Court to hear a quote-unquote assault weapon ban case, either out of Maryland, the Bianchi case, or one of the several Illinois cases involving the Illinois quote-unquote assault weapon ban. Now, it is true that it is highly unusual for the United States Supreme Court to hear a case before the United States Court of Appeals hears it first and rules on it. But it's not impossible. It does happen. And in fact, as we're going to talk about in this video right here and right now, it just happened in a case out of Texas and Idaho this term. Let's talk about all of it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of many books, including Disarm, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, so I want to give you some reason for optimism, reason for hope that the United States Supreme Court will grant cert in one of the quote-unquote assault weapon ban cases that they are being asked to hear next term. Specifically, you all know from this channel and probably other things you've read that the Maryland quote-unquote assault weapon ban case known as Bianchi, there is an attempt to get around or to bypass the United States Court of Appeals for the Fourth Circuit out of Richmond, Virginia, and Maryland because of the games that they have played by sitting on that case for over a year and then granting en banc review, all in an obvious transparent attempt to make sure no favorable Second Amendment ruling comes out of that court. At the same time, we know that Illinois, after Bruen, passed a whole host of new gun control laws, including semi-automatic rifle bans, and also there's a series of requests for cert to the United States Supreme Court arising from the Illinois legal challenges. But of course, the difference between the Bianchi case and the Illinois cases is that Bianchi arises from a final judgment that the district court had entered in favor of the Maryland assault weapon ban, propaganda term. But the Illinois cases, of which I think there's 4 pending cert petitions before the U.S. Supreme Court now arising from the Illinois gun control laws, none of those have ever, A, had a final judgment entered in those cases, and B, have never been to the Supreme Court on a final judgment before, where Bianchi, not only was there a final judgment, it actually went to the U.S. Supreme Court before Bruen, and the Supreme Court granted cert to Bianchi, vacated it, and remanded it for further consideration, which is where that procedural posture is. That is why, in my view, if the Supreme Court is going to take a semi-automatic rifle ban case, also known as an assault weapon ban case, propaganda term by the left, of course, they're going to take the Bianchi case because it's on a final judgment and not one of the Illinois cases because those are on interlocutory appeals, meaning there's never been a final judgment. That is even though there's some very good attorneys in the Illinois case, including Paul Clement, the former Solicitor General of the United States, who has argued Heller, Bruen, and McDonald. He's on the brief in Illinois, but he's not on the brief in the Bianchi, Maryland case, but another powerful Second Amendment law firm, Cooper and Kirk, is on the brief in the Bianchi case, and I think they will be viewed as comparable to Paul Clement because they argue many cases before the U.S. Supreme Court as well. So I don't think there's going to be a problem with the attorneys in the Bianchi case versus the Illinois cases, and that's why I think the tie will get broken by the procedural posture that Bianchi's on a final judgment, the Illinois cases are not. So with that said, many people have said to me, Mark, it never happens that the U.S. Supreme Court hears a case by bypassing the United States Court of Appeals. That is simply not true. It is true, it is rare, but I want to give you reason for hope and optimism here because this term, specifically this term, the United States Supreme Court granted cert in a case dealing with federal Medicare law versus state abortion laws. And in this case, which we'll talk about briefly in a second, the U.S. Supreme Court took the case before there were final judgments on the matter and before, in this case, the Ninth Circuit Court of Appeals could weigh in on it. Specifically, the Supreme Court justices took up this abortion Medicare case that pitted state law versus federal law. Now, the quick facts of this, you don't need to belabor the point. The only thing that really matters for the Second Amendment purpose in the Bianchi case and the Illinois cases is that the Supreme Court not only took this case, they skipped over the Court of Appeals' ability to make a decision in it. Now, what the case, which is Moyle versus the United States, is about is that you had Texas laws and Idaho state laws that restricted abortion procedures in certain instances. And then you had a federal law known as the Medicare law that says that if a hospital receives Medicare funding, they are required to provide abortion-related services by virtue of what the Department of Justice, how they interpret the various federal laws that touch fingers with Medicare. So there was a series of lawsuits in Idaho and in Texas about which law trumped. Was it the generic Medicare law that says that you have to offer necessary stabilizing treatment for pregnant women? And does that trump the sort of anti-abortion laws in Texas and or in Idaho? And the Fifth Circuit said that the federal law did not trump it. And then Idaho's federal district court basically ruled in favor of the Biden Department of Justice. There was a request to the United States Supreme Court in that case asking the Supreme Court to enjoin the decision by the district court, which is the lowest federal court on the system, and to enjoin or to stay that decision by the district court and simply skip over the Ninth Circuit. And the Supreme Court not only went along with the state of Idaho's legislatures to stay that decision against the Idaho abortion law, the Supreme Court took it to the next level and they granted cert and just took the case to resolve this conflict between whether or not the Emergency Medical Treatment and Labor Act, which is part of the Medicare statute, whether or not that trumps the Idaho state abortion laws and the Texas abortion laws. So again, the reason why I bring this up here is not to talk about abortion, but is to show you that as a matter of legal procedure, it is possible for the Supreme Court to simply take a case right out of the district court, skip over the courts of appeals, and decide a case on cert themselves, which they are already doing in at least one case this term. Again, the Moyle versus United States case. So with that said, this precedent is going to be fresh in the court's minds as they are looking at the Bianchi case and the Illinois cases involving the in common use for lawful purposes by Americans test, the constitutional test that came right out of Heller, and the fact that the most popular rifle in America is getting banned all over the place, or not all over the place, but in the typical anti-gun blue states. So we'll see if the United States Supreme Court steps up and does the right thing and takes this case, and I think it will be Bianchi, if anything. And keep in mind that that decision the other day by the Ninth Circuit Court of Appeals in the Teeter versus Lopez case that deals with the butterfly knives to reverse a victory for the Second Amendment and to take that case en banc is also going to get the attention of the Supreme Court and really just reaffirm the importance of the court to step up as an institution and to put the inferior courts, the lower courts in place, because they are simply, some of those inferior courts in the anti-gun jurisdictions of California and New York and New Jersey and Illinois are thumbing their nose at the U.S. Supreme Court. And if I were on the Supreme Court, I would want to rectify that and make it clear how the hierarchy works under Article 3 of the United States Constitution, which is the article of the U.S. Constitution that defines who's the Supreme Court and who are the inferior courts and how that works when there's a conflict between the two of them. So there you have it. So reason for hope, reason for optimism. You probably haven't been able to connect the dots involving this abortion Medicare case, but this gives us hope for the Bianchi and the quote-unquote assault weapon cases that we're seeking to have, or the Second Amendment community is seeking to have, heard by the United States Supreme Court right here and right now, despite the fact that the Fourth Circuit Court of Appeals and the Ninth Circuit Court of Appeals and the Seventh Circuit Court of Appeals and all of them are dragging their feet and or thumbing their nose at clear Supreme Court precedent. So there you have it, folks. Hope you learned something here today at the Four Boxes Diner. Make sure you subscribe and resubscribe. A lot of people are getting knocked off the list, so resubscribe if you're not sure. Don't forget to follow me on X at Four Boxes Diner, where I post several things every day in addition to my videos. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.